All rise. The First District Court of Appeals now in session. All who have business before this court, draw near, give attention, and shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Thank you. Please be seated. Welcome to the First District Court of Appeal. We have two arguments on our docket this morning that we will take in order. The first is case number 22-3516, Shenafield versus XL Specialty Insurance Company et al. When appellant's counsel is ready.
May it please the court. Lindsay Lawton on behalf of Jennifer Shenafield. I'd like to reserve 5 minutes for rebuttal, please.
Noted. Thank you.
Thank you. Your Honors, this case boils down to the fact that Shenafield's treating physicians repeatedly referred her for treatment during the time period at issue. That fact alone establishes that she was not at MMI during that time period. And for that reason, the order on appeal should be reversed. The order on appeal conflicts with the statutory definition of MMI, and the JCC denied benefits because he substituted his own opinion for the medical evidence. Shenafield's arguments rely on the statutory meaning of MMI and the medical evidence in this case, none of which is conflicting, and all of which shows that Shenafield reverted to a temporary disability status during the period between September 8th, 2021 and July 11th, 2022.
When did that revert? What was the date of the reversion to?
Well, the first evidence we have of the reversion is September 8th when she visited Dr. Fiore, and he examined her and determined that an MRI should be ordered to figure out what was going on because her condition had worsened to the extent that her pain was unbearable, so she felt she needed to see a physician. And he ordered an MRI. She got an MRI. Dr. Fiore reviewed it, determined that it warranted her seeing Dr. Shaw, her authorized physician who originally gave her 2 surgeries on her shoulder. And Dr. Shaw, in February 2022, saw her, looked at that MRI, and found, based on the objective showing on that MRI, that she required referral to a specialist.
And under your theory of the case, if she decided again tomorrow, you know what, I'm still hurting and want to go and see what the doctors have to say, and essentially it seems like the same thing could just happen again, that one refers to the other, and they say you can have surgery or not. No, I'm not going to do that. And then next November we'll do it again. And then are we constantly in that state of MMI, not MMI, MMI, not MMI, on the basis of getting the same kind of opinion and deciding I'm not really interested in surgery?
I understand the concern, Your Honor. That any future petition based on a reconsideration of whether she wants surgery would have to be evaluated based on the circumstances and evidence existing then, and that evidence would include the history of these petitions and what happened happens here in this case. It might be that in the future TPD benefits or TTD benefits would start from the date she has the surgery, since she's already had this period where she has the opportunity to make a decision, and where she's already. So
in this first go around, the date is different than it might be in subsequent subsequent incidents, and basically it's just kind of a factual call by the JCC as to the authenticity of the request or what's happened in the past and how that informs the future. It's sort of a floating type.
I guess in the future
reversion.
petition, we'd have to hear the EC's arguments for why she shouldn't be entitled at that point. I wouldn't say that there's any authenticity issue here on this record for this case, because I mean she has an objective MRI. Right. If you look at the statutory definition of MMI, you can see from the doctor's actions here that they expected that she could get some lasting recovery, and also the concerns that might be existing regarding continually changing one's mind can be alleviated by recognition of the fact that the case law and the statute limits the number of weeks that a claimant can get temporary disability benefits. So that kind of concern shouldn't interfere with whether she can have benefits for this case. What should matter is whether the evidence shows she was not at MMI for the period at issue.
Does the statutory definition of MMI require treatment?
It does not, Your Honor, it does not say treatment, and that's, of course, a hotly contested issue in the briefs. Our position is whether it requires treatment or not, the circumstances of this case show that she was not at MMI. And the reason I say whether it requires treatment or not is that it seems the EC has one idea of what treatment might be, and we have another one. I submit that our view of what treatment is actually based on the case law establishing that treatment includes evaluation and diagnostics and referrals to physicians. That's established in this court's opinion in Nunez, cited in the briefs.
But that gets us back to what would happen next year, and you seem to say, well, then we wouldn't look at the evaluation perhaps because we've been down this road before, and so the rule would be different.
Well, if she were to come back next year with another petition, I think we would have to say, and she's getting evaluated again by physicians that are saying, let's look for an option for you to heal and remedy the condition that you're experiencing now. We would have to say that she's not at MMI at that point still. But again, that shouldn't be of great concern because she can't abuse the system that way. The statutes in the case law limit the amount of time you can get temporary disability benefits for. Also, at that point, there could be a question, a factual question perhaps, about whether she's cooperating in her treatment. That could be assessed based on the evidence existing then. One of the cases cited in the briefs, Variccio, says a claimant has an obligation to cooperate in her care, and that eliminates the kinds of concerns that you're raising, Judge.
But apparently, your view is when you say cooperating in treatment or care is just she's not cooperating with going back for another evaluation from another doctor, since that's apparently included in the definition of treatment. So,
could you repeat that question, Your Honor?
well, you're telling us that the treatment could include just evaluations every time she goes back to see a doctor just to be looked at again. That's part of the treatment. And so you're saying, well, that it doesn't preclude a claim or an issue later whether she's cooperating in the treatment. I mean, how broad do you expect this to be read? And I guess I'll add to it the question, what's the point of getting a final compensation order or determination of MMI if you can just go back to another doctor and have that second guessed 6 months later?
Well, going back to your first question, the word treatment, I think we can refine it a little bit to say it's not necessary. It's not just that she goes to a doctor for an evaluation, but that she's getting diagnostic tests ordered. The doctor, when you look at the definition of MMI, it's based on what the doctors believe, what the doctors' medical opinions are, not Shenefield's subjective belief that she needs to go back for an evaluation. So when a claimant goes for an evaluation and the doctor examines her, orders diagnostic testing, and starts making referrals, that is treatment. That is based on the doctor's objective medical opinion, and it's not subject to any kind of abuse or gamesmanship that might be a concern.
Was the claimant referred to Dr. Donaldson?
Yes, Your Honor. And both Dr. Shaw, Dr. Donaldson, and Dr. Sando were all authorized treating physicians. Dr. Shaw, again, was the one who originally did the surgery, and he said, yes, she needs to see someone more specialized than I am because she does have an ongoing problem. The surgery I did not fix her condition permanently. He apparently thought that it did when he gave her an MMI date in March of 2021, but even Dr. Shaw reconsidered that. And that's just based on the reality of how the human body heals sometimes, and Shenefield didn't heal fully from that surgery as anticipated.
What's the role of Dr. Fiore in this?
Dr. Fiore was the IME.
Was there a PFB pending when?
I'm sorry?
Was there a PFB pending or a claim pending or a dispute remaining at the time Dr. Fiore is looking at her?
No, Your Honor.
So then how does that fit the definition of an IME
Uh,
under the statute?
I'm not sure, Your Honor. That is not an issue that was raised in the briefs or one that I was.
Well, but I mean, you've set out, like, Dr. Fiore, this is where it all starts. Dr. Fiore looks at her, quote, as an IME 6 months after the FCO comes out establishing MMI, right, and placing her in MMI 10% or whatever, 11%. And then she goes back. I mean, I think that the case kind of turns on that. If a claimant is established at MMI at a certain level, is put on permanent, gets, impairment benefits, and then can go back to someone that you classify as an IME, which is not contemplated in the statute, to then reevaluate and second guess what's already been determined.
Your
How
Honor,
does that
the
work
EC
under the
never con-
statute?
I'm sorry?
How does that work under the statute? I just don't understand then. It goes back to my second question, which I know got lost because I was asking the first question, which is what's the point then of having a JCC make a determination of MMI?
Well, what I can say here is the EC didn't ever contest that Dr. Fiore was an IME. And also
Was
was
that the JCC's job to contest it?
if it's an issue in the case, and in this case it was not raised as an issue, the issue is simply whether she reverted to a temporary disability status, and that's based on what the medical evidence is for the period in question. And the other important thing to remember is we're not just relying on Dr. Fiore. We're relying on the three authorized treating physicians, none of whom said she was at MMI during this period. And those authorized treating physicians, including Dr. Shaw, relied on the MRI that Dr. Fiore ordered.
Sure, but they also they didn't say that she, I mean, you're sort of classifying as a negative, like you're talking about a statement in the negative. So, I mean, their job wasn't to determine whether she was an MMI.
Well,
They weren't deposed. They didn't testify. You have some doctor's notes. They were referrals. Dr. Fiore, who you're placing a lot of legal significance to, but I guess your answer is yes, a claimant can go to a doctor after they get placed at MMI just to second guess and offer another opinion as to whether she in fact was at MMI. Is that right?
no, Your Honor. There's no indication in this record that Shenefeld was simply second guessing something. There's an indication.
No, I'm talking
that-
about Fiore. I mean, I know that I'm not talking about your client. I'm talking about Dr. Fiore.
Well, and Dr. Fiore wasn't second guessing anything either.
Well, what was he doing?
He was examining his patient
For what purpose?
to determine if she needed further intervention to resolve her problem. And that he determined
Wasn't that
yes.
already determined by the JCC?
It had been determined for the period at issue previously, and then the circumstances changed. And it's not just Dr.
Did she continue to have pain? Did she not have pain before?
She had pain before.
Sure.
After surgery, as one does, but Dr. Shaw released her, believing that his surgery had been successful. The circumstances that developed later showed that it wasn't. And remember, it's not just Dr. Fiore who said that. It's even Dr. Shaw who did the surgery. He referred her to a specialist. And a doctor doesn't do that if for no reason. He wasn't wasting Dr. Sando and Dr. Donaldson's time by making that referral.
And it was something about the interaction of bone growth and the device that was implanted at surgery that was causing something. Is it?
Exactly. And then ultimately, Dr. Donaldson determined that a way to fix this would be to remove the cage handle that Dr. Shaw had installed. And if there's a concern about, not relying on Dr. Fiore, then at a minimum, I would say, at least when she saw Dr. Shaw, the treating physician who did the original surgery, who's authorized by the EC, and Dr. Shaw reviewed those MRI findings and referred her to a specialist, at least from that point, she should be entitled to benefits. And also, going back, Judge Tannenbaum, to your point about relying on a negative. I'm not relying on a negative. Dr. Shaw, his office notes referring her to a specialist showed she was not at MMI. Also, Dr. Sando and Dr. Donaldson, both authorized treating physicians, said expressly she's not at MMI. Dr. Sando gave her restrictions, continuing the restrictions that Dr. Fiore had recommended as well. And the fact that they were not
The
deposed.
facts really, I mean, those are legal conclusions. I mean, the real question is, as a factual matter, what was there left to do? I mean, what was the next thing? I mean, I guess we know. I mean, there could have been surgery that would have helped, which she chose not to do. But where does that leave the employer at the end of the day? It seems like the employer is left in limbo all the time until just because the doctor says, well, yeah, I think there may be something else that you can do that would help. And she doesn't have to actually do it to then go back to temporary disability?
Well, any position of limbo that this employer carrier is in is because of what the statute requires. The statute requires ECs to give all medical care that's necessary for the duration of the injury. And so there's no limbo. And again, that also, I think your concerns can be ameliorated by going back to the fact that temporary benefits are limited by statute and case law. And
Well, you have to qualify for them first, though. I mean, whether there's a limit or not, the statute sets out what you have to establish before you can get the benefits in the first place.
And we submit that the statutory definition of MMI compared to the evidence in this case establishes that she was not an MMI and was entitled to temporary benefits. And I see that my time is expiring.
Counsel,
Before you sit,
Yeah, go ahead.
on July the 11th of 22, claimant advised Dr. Donaldson that she was not interested in pursuing any type of surgery. Is that correct?
That is correct, Your Honor.
Would it have made a difference if she made that decision 3 months later for purposes of an MMI date?
That arguably would have been an unreasonable period of time to make the decision. I think if that occurred, the arguments would be different, and we would have to make that decision based on those facts. The point is that, there has to be a reasonable amount of time to make a medical decision. Shenefield took 3 weeks. She made the decision by her next medical appointment. That can't be considered unreasonable. She was cooperating in her care. If she had waited 3 months, it might have been a different story.
Thank you, counsel. And why don't we add 2 minutes to each side?
Thank you, Your Honor.
May it please the court. My name is Bill Rogner, and I represent Consulate Healthcare and their carrier in this case. Of course, we had trial one. The late Judge Dietz ruled that the claimant reached overall MMI on 3/2/2021, final order not appealed. And this is about trial two, and the question that, as we look at it, is did anything change, and we think the answer is no. So factually, here's what happened. Claimant apparently wants, this isn't about MMI, this isn't about medical care. We never denied a single medical claim in this case. Claimant apparently wants to try to get more temporary disability benefits, so Dr. Fiore is hired. Dr. Fiore says, not an MMI. But that's an IME doctor. That's really not something that concerns us in the way that we look at cases. We look at the treating doctors. She goes back to Dr. Shaw, 2/6/2022. Doc, I'm having problems. Now, why can she go back to see Dr. Shaw if she's at MMI? Because the right to receive medical care doesn't end with MMI. She has a permanency. She potentially has the right to lifetime care. What is that care called? It's called palliative care. It's right there in the statute. That's post-MMI care.
Counsel, you make a statement in the answer brief that claimant declined the only remedial treatment offered, I guess, which was surgery.
Yes, sir.
If surgery was an option that could have helped her, then was she not at MMI when she was seeing the various doctors?
She was at MMI because, first of all, we have an order that says she's at MMI. And second, she didn't get the surgery. There are lots of cases where an injured worker is at MMI. Statute says, 440.15.2a says, temporary benefits cease. That's the statutory language.
Is it your position that claimant's MMI status did not change until surgery or other remedial treatment actually occurs?
Correct. That is my position, Your Honor, that had she received additional remedial care, then there's the potential that the MMI date could change. We've got all these cases, Parker, Rowley, Utley, James, Brown, Kirkland, Delgado, Florida Power, that are cited in the briefs. And in every single one of them, claimants at MMI, they now want more money. They want more temporary disability benefits. And in each of those cases, they received additional remedial treatment. Additional remedial treatment of some kind. That's what's in those cases, okay?
So is there any case like ours where basically there's an acknowledged problem, but the claimant just says, I'm not going to go forward, even though there is a problem that I could get surgery for?
Yeah, I don't know that there's an exactly analogous case that's a first DCA case. We have thousands of JCC cases because this is not something that's reasonably debatable, in my opinion. So what happens is she goes back on February 2nd to Dr. Shaw. She's entitled to. Post MMI, she's allowed to go to the doctor. Do you change the MMI date every time someone sees a doctor? No, of course you don't. You change the MMI date if there's some legitimate reason to change the MMI date. What does he do? He says, I can't help you. He completes his DWC 25. He doesn't complete it. He signs it. And the only thing on page 2 where you address restrictions and you address MMI, you address the rating, is no delta. That's what he writes. No
But
delta.
Dr. Donaldson offered surgery, is that correct?
I'm sorry?
Dr. Donaldson offered surgery for the claimant.
But we're not there yet. Absolutely, he offered surgery. But what happened between...
But if surgery could have helped her,
Absolutely, it could have helped her.
then would she not be at MMI?
She is at MMI. She didn't get the surgery. What she does is she goes to Dr. Sando. We authorize that because we're obligated to. Dr. Shaw says she needs to see a specialist. Turns out he's not the right one. He says, I can't help you. You need to see Dr. Donaldson. Maybe he can help you. She goes to Dr. Donaldson. That's June 22. Dr. Donaldson says, okay, there's a surgery we could do. And if you read the record, it sounds like it may or may not work. And apparently she wanted to think about it and talk to her husband about it. She does that. She comes back 3 weeks later and says, I don't want it. So what treatment was provided to her during all of this relevant period of time? None. Judge Tannenbaum, you wrote something I liked a lot in Jones v. Grace Healthcare. A medical evaluation is not the same as treatment. And once you've reached MMI...
But since Dr. Donaldson offered her surgery, didn't he think that improvement might be anticipated, which means that she was not at MMI because she offered her surgery?
She was at MMI, and the reason she was at MMI is she had already reached MMI with permanency, and we already have a final order finding she was at MMI with permanency.
But there's essentially a new problem. Something with the surgery wasn't perfect or right or what have you. You have this device, you have the bone, and it's causing issues.
No question.
And so there, it seems like, I mean, it doesn't seem like it would be fairly common that post-surgery, sometimes there are things that come up, and
Happens all the
one
time.
at MMI all of a sudden isn't an MMI anymore.
Well, that's what they want you to do,
Sure.
is every time the claimant goes back to the doctor and says, hey, I'm worse, and the doctor goes, what a doctor's supposed to do? Well, I'd like to help you.
Well, that's where the statute is tricky for us, right? This is an interesting one because what it says is no longer reasonably anticipated. And if it is reasonably anticipated, it's just that the claimant ultimately says, no, I'm not going forward, even though the claimant could be helped, then we're in this place that's in the joints, so to speak.
Well, I
Yeah,
think it's pretty simple. I think there's a simple resolution, and I agree that it. All right. So, for example, remedial care is not defined in the statute. I look to your cases to tell me what that is. Palliative is, but remedial isn't. MMI.
But do you agree that under our case law, remedial treatment includes diagnostic testing and referrals to specialists?
I do not agree that that's what your case law says. There's one case ever that says that a diagnostic test, an X-ray, was considered remedial care. One, IMC phosphates versus Prater. And that's not about MMI. It's not even an MMI case. It's a 440-092 subpart 5 case, and that's a subsequent intervening accident where the claimant's going to the doctor. The only subsequent intervening accident that's covered is when they're going to or from the doctor, and the statute said remedial care. And the claimant was on his way to his doctor to demand an X-ray because he thought there was something not right. And he gets in a car wreck, and the defense goes, that's not covered because an X-ray isn't remedial care. And the court said that's sufficient to satisfy
But
that
if
statute.
surgery is an option that could have helped her, then is she not an MMI?
Sir, I concede that had she had surgery, we would have been obligated to provide her with temporary disability benefits. But she is already at MMI. It's already been determined.
This really comes down to how we view the JCC. So it sounds like your opposing counsel suggested at the beginning of her presentation that the JCC substituted his own opinion for the opinions of the doctors. But that's not, I mean, the JCC, what we expect JCCs to do is to hear this evidence or read the evidence and make findings and reach conclusions on whether the statute's established or, whether there's an entitlement. And in this case, it sounds like what the JCC determined is, based on the evidence that was presented, that even if surgery was an option, if the patient says that she's not going to get the surgery, then isn't it a reasonable probability that she's not going to improve?
Yes.
And isn't that what the JCC determined? It's like, well, if she's not going to get the surgery and that's the thing that's going to make her improve, and she says she's not going to do it, then it's reasonable to conclude that she's not going to improve.
I think that's a fair reading.
At the point she says she's not going to have the surgery.
I'm sorry, sir?
At the point she says she's not going to have the surgery.
Well, I'm not sure the point that she says she's not going to have surgery should control. I mean, that places the decision of MMI not in the doctor's hands or in the judge's hands, but in the claimant's hands. I'm just not sure. I'm just not sure. I'm just not sure. And that means you're not at MMI, you're not at MMI, you're not at MMI. I mean, you have to think about what's going to happen should you reverse this and send it back. Not in this case. Our individual cases are relatively minor importance except to the parties. The most important thing is, what does the case do? And if you write an opinion, you send it out, you say, well, since the claimant went back and they talked about some other options, the claimant was no longer at MMI. And what that means is they don't. So the only options were between June 22 and July 11.
Your statement, but then Dr. Donaldson specifically offered surgery to her.
Yes, I can see that.
And at that point, wouldn't you think that that Dr. Donaldson thought that there could be possibly some improvement because of the surgery?
Your Honor, I don't dispute that she was offered surgery. I don't dispute, but I don't
And what was the purpose
think.
of offering surgery? For purposes of improving her condition?
Of course, that's exactly what it's there for. But she decided not to have it. But
And couldn't there be, based on what the evidence that was presented, what's the JCC supposed to infer from? It would have been easy for her to testify and say, I wanted to get, I meant to, I scheduled it, but then the bad employer came in and has already denied it, so like, what am I supposed to do? As opposed to, it's ambiguous. There's no real statement that she was planning on getting the surgery, right?
well, I agree. There's no suggestion or indication that she ever wanted the surgery, ever. It was discussed as a possibility.
Right.
But
And so where does that cut with the burden of proof? Like if the claimant presents like, hey, I've got these doctor's notes, you make of them what you will, and there's this mention of surgery in the notes, and kind of like, and then leaves it at that and doesn't make a statement and say, yeah, I'm going to get the surgery, something like that. What's the JCC supposed to infer? That she is going to get the surgery or that she's not going to get the surgery? We don't know. And how do you make the determination about probability in that instance?
I have no idea how to answer that question or how a judge would answer that question.
But that's what we have to decide, is like, well, was there enough evidence to support the JCC's determination that despite the recommendation that there was surgery, that...
I'd respond in two ways. Number one, the judge weighed the evidence. He went through it in detail, considering whether or not she was at MMI, and this court says over and over again, we do not reweigh the evidence and substitute our judgment, which I think is what you're being asked to do. The second thing I would say is you also write that the party without the burden of proof, me, need not show that the order is supported by CSE. This is a their burden case. And remember, this is not about MMI. It's certainly not about surgery. It's about the indemnity benefits. It's about the money benefits. That's what the claim's about. And they have a burden to prove, in order to have the prima facie entitlement to temporary partial disability benefits, that the claimant is not at MMI. We already have an adjudication that she's at MMI. I suggest to you that there must be something more than a mere discussion of possible treatment. If you look at Emanuel versus David Piercy Plumbing and Benefield versus City of Lakeland, they both say the same thing. The potential for receiving benefits or medical care in the future does not change the MMI date. Now, they're in the context of permanent total disability benefits, where the defense is saying, wait a second, Your Honor, they're going to need this surgery in 6 months or a year. So they're not at MMI yet because I'm trying to defend this PTD case. And the court said, no. They're at MMI right then.
So if she decided to get the surgery, what would be the date of not MMI here?
The date she gets the surgery. So when she says, for someone that's already at MMI, and she says, okay, if you look at a lot of these cases that are cited in the brief, somebody has typical situation, Judge Osterhaus, is this. I have a knee meniscus. I get my surgery. I get it fixed. I reach MMI. I have a rating. I continue to treat. 5 years go by of palliative treatment. I get regular treatment. I get injections. I get all this stuff.
What if the surgery was blocked by a third party? Supply chain, the government all of a sudden says you can't use that kind of device, what have you. So you reasonably anticipate this getting fixed, but in the meantime, you got regulatory or supply or something hurdles.
Okay, so maybe it could be when the claimant decides to get the surgery. I'm not sure how that could work, Judge, but I know this. If I have a surgery 5 years later to replace my knee, does that mean I was never at MMI? Because that's what they're asking for. They're asking for retroactive benefits going back to September of 21. September of 21. And she didn't see Dr. Donaldson to discuss surgery until June of 22. And that's what this case would do. People will say, wait a second, I'm going to go see my doctor, ask my doctor for options, and if the doctor says there are options, then I was never at MMI in the first place. And now I can go back in time and get my temporary disability
Well, isn't
benefits.
it more, there was MMI, but at some point, because of the surgery complications, presented a new issue that, and maybe it's not the September, but at least when she goes back to the surgeon says, yeah, there's a problem here in February.
Okay, well,
that, you know,
I don't know that it would be when Dr. Sando sees her in February, because all he says is no change. And he just says, I can't help
did
you.
Shaw see her in February?
I'm sorry?
Yeah.
Shaw, thank you.
Yeah.
Says, I can't help you, no delta, sends her out. The first doctor that discussed surgery, only doctor that discussed surgery, Judge Lewis, is Dr. Donaldson, as you've pointed out, when he saw the patient on June 22, 2022. That's the first time that anyone discussed this surgical procedure. And 3 weeks later...
Yeah, but even Shaw referred on it, as I understand, to a upper extremities surgeon.
Upper extremity specialist.
Yeah.
This is beyond my capacity. You need to see somebody else.
Yeah.
Right? And then the decision-making time between the time that the doctor discusses surgery and the time she declines it is June 22 to July 11, 3 weeks. Okay? But I do believe that just makes it an untenable test for us to apply below. Just when the patient returns to the doctor to receive routine follow-up care, that doesn't change MMI. We know that. That's palliative treatment post-MMI. It would be a completely untenable system if the claimant gets a new MMI date with every visit. We know that can't be right.
Yeah, but it's a tough characterization under these facts where it seems like there is a complication that as a result of the surgery hasn't performed as intended. Therefore, we need to address this new thing.
You might be reading, with all due respect, I think you might be reading more into that very brief Dr. Shaw medical report than is actually there. I mean, he evaluates her. He does what doctors commonly do when they're like, look, he doesn't say this, but this is what happens. This is all I got. I don't have anything else for you. Let's refer you out to somebody who might be able to help you. That happens all the time.
But they seem to put a finger on it ultimately, that it was this device in the bone growing together or something.
Yes.
That caused it.
And again, if she'd undergone the surgery, we wouldn't be having an argument. I mean, we might be having an argument because they'd still want to backdate it to the IME date, which I don't know why that was an IME either, but I didn't try the case, Judge Tannenbaum, so I don't know why that was really not made into an issue.
Counsel, let's assume, for the sake of argument, that a claimant is at MMI, but a new curative treatment comes out. A doctor refers her to a specialist. The specialist says, yes, this treatment can help you. Is she not at MMI at that point?
Your Honor, I think the claimant has to receive some additional remedial care for the MMI that it's already been previously established to be the date for it to change. Otherwise, it's just too subjective. And in this case, they say, well, Dr. Shaw refers her out, so now she's no longer an MMI. She's received nothing. These doctors didn't give her a medicine. They didn't give her a brace. They didn't give her therapy. They didn't give her a procedure.
And these doctors are not acting as experts, right?
No, and they weren't deposed. They could have been deposed by either side. They're just being doctors.
So what is is there any legal significance or status whatsoever for Dr. Fiore and his original opinion that, actually you're not at MMI?
As you have been able to see from my presentation here, I have not spent a lot of time worrying about Dr. Fiore. Sure. The judge provided an entire paragraph of this order about why he rejected Dr. Fiore. Dr. Fiore was hired for a reason. Dr. Fiore is an IME doctor who was hired to provide an opinion. I think what's much more important are the opinions of the treating physicians and whether those opinions are sufficient without the provision of any actual medical care to change an MMI date that's been adjudicated by prior order.
But we actually don't have the opinions of those treating physicians, right?
No, we do not have testimony.
We have
and in fact, we don't even have the records from the prior adjudication. And I don't even know if they were deposed in that case either. But we don't have opinions, we have reports.
Are you able to compare, based on the record, are you able to compare her condition right before with the evidence presented to the JCC who put her in MMI and compare that with her condition 6 months later when she sees Dr. Fiore?
Am I able to do that now?
Yeah.
No.
Was there an absence of pain? I mean, do we know?
No, I don't think the record would support that there was an absence of pain. I mean, she had a big surgery and she had a 10% permanent impairment rating, and we paid her benefits for her permanent impairment rating. So I don't dispute that she's injured. I just dispute that she's received additional remedial care. And I think if you're just receiving palliative care post-MMI, it doesn't change the MMI date. All the other cases, there's at least some additional curative care that's provided to the patient that justifies the sort of rescission of MMI. This is not a case where the claimant never reached MMI. The claimant reached MMI.
Thank you, counsel.
Thank you, Judge.
And if we could add 3 more minutes to appellant's counsel.
Thank you, Your Honor. Shennefield is not asking for a determination that she was never at MMI. If she was asking for that, she would be asking for temporary disability benefits from March of 2021. Instead, she's asking for temporary disability benefits from the time where the evidence emerged showing that her condition had changed to the point that new surgical intervention was something to be considered. It's been said that we don't have any opinions of treating physicians, that she was not at MMI. We do, though. The DWC 25 forms from Dr. Sando and Dr. Donaldson, who are authorized.
How does a box check on a government form count as an opinion?
Well, the doctors didn't just blindly check the box. They read it, presumably.
Presumably, right?
And I
we don't
believe
know because we don't have their testimony.
Well, there's no requirement that we have their testimony. The reason that these DWC...
Well, there may be a requirement if you have the burden of proof. I mean, it may be a good idea to present something.
These forms exist to provide an expeditious way to deal with the workers' compensation system, and they are evidence that was submitted to the JCC. He didn't say they weren't evidence. He evaluated them and rejected the medical opinions that she was not an MMI. And I think we have to presume that these doctors thought about what they were doing on the form. And if I remember correctly, I think they even handwrote, I'd have to go back to look, but I think they even handwrote something about her not being an MMI. And Dr. Donaldson specifically said he changed her to an MMI status on July 11th, 2022.
But we don't know whether any of those doctors knew what MMI meant or whether it had a specific meaning in the context of their treatment. We don't know what they were actually saying, right? Based on
think we
a
can
note.
presume that they wouldn't say things they didn't know if they didn't know what they were talking about.
Well, is that how evidence works in burdens of proof? Presuming? Or is it actually presenting evidence from which you may make inferences. Maybe the JCC could make inferences, but he's
Maybe-
also the fact finder, and he could choose not to make an inference from that.
Well, he said that they were credible and objective in the end of the order when he was comparing and contrasting them to Dr. Fiore.
Counsel, is there any evidence in this record that the doctors did not know what MMI was?
There is not, Your Honor. And there are reasons to infer that they did know, because, again, these are professional physicians chosen by the EC who work in the workers' compensation system. They evaluated and gave diagnostic testing to Schoenfeld. They made notes consistent with the point that she was not at MMI, including referrals and offers of major surgery.
What's the answer to the question? Could the JCC not infer from from your client's failure to get the surgery that she was not going to get the surgery?
The JCC didn't find that. I don't think there's any basis in this record to infer that. There's never been a suggestion that Schoenfeld was anything but genuine. It seems eminently
Genuine in what sense? That she was planning on having the surgery and just didn't?
that she was going to consider the remedial recommendations by her physicians and decide what's best for her health.
What was the basis for the referral to Dr. Donaldson?
The basis for the referral to Dr. Donaldson was Dr. Sando's review of the MRI and Schoenfeld and determination that she would probably be a candidate for open shoulder surgery or arthroplasty, and his inability to perform those surgeries because they were outside of his specialty.
And did Dr. Donaldson offer the surgery?
He did, yes,
And why did he offer the surgery?
because he believed that the surgery would give Schoenfeld improvement to her condition, which, when you look at the MMI definition, means she was not at MMI and was entitled to temporary.
If she chose to get the surgery, the employer would pay for it, right?
Yes, Your Honor.
And I imagine that even to this day, had your client gotten the surgery, she could have walked back into the JCC and asked for reconsideration or filed something new to say, I've now gotten the surgery, so now put me at MMI, right? I'm assuming the fact that we're still here having this argument that your client still hasn't gotten the surgery.
Well, that information would be outside the record, but we can assume that she hasn't gotten the surgery, if you'd like. I'm not sure how that affects the.
But she's still thinking about it, I guess, right?
We can assume that she's not still thinking about it because she made a decision on July 11th, 2022, not to have the surgery. And Dr. Donaldson put her back at MMI because of that.
Thank you, counsel.
Thank you, Your Honor.
All right, our second case for today is case number 22-2721, Chambers versus Tallahassee Hotel. Counsel for appellant.
Thank you, Your Honor. May it please the court, my name is Brian Lee. I represent Brandon Chambers. As the court knows, this case comes from a summary judgment entered by the trial court on the issue of notice, and there are some evidence that we believe should have led the trial court to conclude that certainly with the either actual or constructive notice, that issue should have gone to the jury.
Would you like to reserve any time for rebuttal?
I apologize. I would like to reserve 4 minutes for rebuttal.
4 minutes, thank you.
Thank you for letting me know. So actual knowledge, we believe we have both. We believe we have both evidence of actual knowledge as well as constructive knowledge or notice, however interchangeably they are. Actual knowledge exists in this case because Mr. Chambers was able to present evidence to the court that Tallahassee Hotel, its employees or agents, knew of or created the dangerous condition, and that is the refrigerator. that's in this case. They were the ones that put the refrigerator, of course, in their own hotel room. They put it in the manner that they did. They made it so that they could not actually maintain.
How is the hotel within the definition of business establishment as used in the statute? Is it not a public lodging establishment instead, and does that make a difference?
If it's a public lodging, Your Honor, that could, hotels have been brought into, or have, I guess, been assumed to be a business establishment because they take, it's part of people coming in.
Well, except that the statute was was enacted for a particular purpose. I think it was to overrule a Supreme Court decision that went the other way, but of course it dealt with a banana peel or something on the floor in a basically a common area where there are invitees. And I guess my question is the statute limited to business invitees and not to, your client, I think, is a different status, isn't he?
No, he was he was an invitee onto the property.
Well, except he had a contract. He paid for a room. And so
Sure.
he's more than an invitee. He's got a contractual relationship with the hotel. And it's a room that he's renting, and Chapter 509 in Florida statutes deals specifically with public lodging establishments, defines them, in a variety of ways. So I'm still wondering, it seems like there's a struggle to fit a round peg into a square hole or a square peg into a round hole, where maybe the statute doesn't apply at all.
Sure, and it may very well be, frankly, that it is under 509. We didn't brief that because it wasn't briefed below, and it was a really kind of a foregone conclusion, I guess, to the court and frankly to everyone that it was a business establishment under that statute. And so it wasn't briefed there below. So, but if we're talking about what he would have been expected as a public, or excuse me, as a going into the hotel and being that way, I think the same type of duties would apply with that. They still have to maintain a hotel in a way that is presentable and suitable for what was there.
And safe.
And safe. And so
But regarding your position.
Yes.
Is it
sure.
your position in this case that to exercise ordinary care, a hotel must continuously re-inspect a hotel room until a guest arrives the same day the room had been cleaned, inspected, and approved for rent?
No, I don't think our position is that it has to be a continual inspection, meaning like they have to go there every 5, 10, 15 minutes. But what we have in this situation, and why Judge Tannenbaum is well taken with that, is hotels are a different situation than stores, because stores have people coming in and out all the time. There's sort of free passage within there. And so when we're talking about leaks and things of that sort that happen with stores, that is a transitory thing. There could be hundreds of people coming in. And so there's a lot of cases that talks about when we deal with constructive notice, so to speak, like how much time it has to be on the floor, all the things like that. What we're dealing with in this case is we're dealing with a situation where there was a hotel that was specifically for Mr. Chambers. They inspected it hours before, but we don't believe that that is the end-all be-all, meaning that once you inspect it, whenever that is, that's all you have to do.
So what put them on notice that there was water on the floor?
What they had, well, we have not only is that because of the installation.
But that doesn't mean there's going to be water on the floor, does it?
It doesn't mean that there's going to be particular water on the floor, but we know that from the evidence that there had been water on the floor in the past, that these refrigerators were prone to failing.
I thought it was like twice.
They said 1 or 2 times that the person did, but it doesn't have to be, regularity doesn't have to be 15, 16,
And then
18 times.
it was that water would go on the floor if you unplugged it, because the ice from the freezer box would melt or whatever.
That's very true, but we also know that that these refrigerators would also malfunction or would break. And we know specifically that in this particular room, that they had changed the refrigerator in that room 8 times in the last 2 years. And
said
so,
it stopped
Due to leaking
cooling.
water.
I'm sorry, what?
Due to leaking water.
No, the interrogatory answer doesn't say that it was because it was leaking water. It said it was because of malfunction. It was inoperable. But I don't believe we have to prove that every single time they changed it was because it was leaking water. They knew that they knew that these
Is there evidence
refrigerators.
in this record that the fridges leak water regularly in these rooms?
The evidence shows that the testimony that I think you've already talked about is the 1 or 2 times that they say when it leaked.
What happens if, let's say instead a hotel installs a refrigerator, and it's the first time, and it explodes while the customer is in their room?
Sure.
And they get injured.
Right.
What's the theory of liability in that instance?
I think it would be different. I think it would be different in that
In what
situation
way?
because refrigerators, part of their
I mean, it doesn't have to be a refrigerator.
Right, part
think of a device or something. The Keurig
Right.
explodes and sprays hot water on the resident.
well, it's not a known condition of a refrigerator or Keurig or something to explode. That's not one of the sort of warnings that if you don't maintain your Keurig or a refrigerator, it's going to explode. But it is part of refrigerators
But are you
that they can leak.
Right, but are you conceding then that a hotel owner is not responsible for a defective product that is placed in the room that injures one of their residents?
I'm saying that, I'm saying something a little different. I'm saying that when they put a product into a room which has a known risk leaking in this situation, especially when you don't maintain it, and then it does exactly what it does when you don't maintain it, which means leaks on the floor, then yes, they are responsible for that.
But it doesn't have to be leaking. It could be anything. I mean, as long as it's a sort of a known risk that could cause harm to a resident. What I'm trying to parse out is, are we here just because it happened, the malfunction leads to water on the floor where there happens to be a statute that mentions transitory foreign substance? If it had not been water and it had been something that flew through the air, would it have been a different case? That's what I'm just trying to understand.
Sure,
what the
it could have been, because then we'd be talking about something that is, and the refrigerator itself right? I mean,
Let me put it differently. I'm
Yeah.
sorry. Is the theory of your client's theory that the hotel was negligent for putting a defective product that was known to be defective, that caused injury in a, maybe not in a direct way, but an indirect way? Or is it, hey, the client slipped on water in the room and they're on notice because it came from a refrigerator that was defective?
I think it would be the latter, because the product, there's no evidence in this case that the particular, which you would have to have, that the particular refrigerator that was in that unit was defective just in and of itself in some way, that it came there defected or something, a part malfunctioned or something. What we do now, because we don't have that evidence, the evidence we have is that the refrigerator was in that position. They put it in that position. That position did not allow them to do proper maintenance on that refrigerator. It didn't even allow them to, it's very clear from the evidence, it didn't even allow them to empty drip pans.
Right, but it sounds like then you're reverting back to a different theory. So that is not just that there was water on the floor that the hotel should have known about and didn't do something about. You're focused on the malfunction of a product that the hotel knew was defective.
Well, it's not, I don't think it's a malfunction, Your Honor. A refrigerator can leak and not be malfunctioning. And the reason that it can leak is because, and the evidence shows, there are drip pans with refrigerators. They collect water. Part of the maintenance of refrigerators is you have to take the drip pan out and you have to empty it. That's part of it.
I didn't think that was part of the record. I thought that it evaporated. I mean, it's
It said
so
that
little
it
water
could.
that it evaporated.
Correct. It said it could evaporate, but they weren't able to check those things and to see whether they actually had to take the water out because they put it in such a way that they couldn't get to it.
Well, we were talking about an inch or two of clearance on either side. I mean, either way, you pull it out, right?
Sure. And they just said that they didn't do that. Whether it's because they put it in the cabinet, they said they never took these refrigerators out. They never checked the drip pans on them. And so it's not that we're not saying that
they don't leak. I thought the record is they don't do that because they don't leak.
No, that is not what the record says.
I mean, they've leaked once or twice in the history.
They did say once or twice, but they said that the reason why they do not take the drip and check the drip pans and do maintenance on them is because they can't get to them. And I think their evidence actually says that we don't pull these things out and maintain them. They just keep them there. And they can't get to it, so they don't do it.
We'll go back to the Keurig machine. So let's say the Keurig doesn't malfunction, but it does have a tendency from time to time to spray hot water, piping hot water on, if you're too close, you're going to get burned. Mm-hmm. And the hotel puts a Keurig in the rooms, in all the rooms, and a customer is in the room and actually gets burned from the scalding hot water that's sprayed from this machine.
Right.
What's the theory of liability in that situation?
There's two different ways of that. If it's a function of the machine, meaning that the machine just
Tends to spray hot water.
operating normally
Right.
would do that, okay, then that's a known thing. But if we're talking,
But the hotel knows about it and installs it in the room. What is the theory of liability? What's the tort theory?
the tort theory would be that if they're putting a dangerous object that just randomly sprays water, even if you maintain it every single day,
Right.
that's a whole other theory. That's a theory that they've actually installed a dangerous part that's in and of itself inherently dangerous.
Well, but so isn't that, it still goes back, I'm trying to understand what the hotel's duty is. And are you equating, basically, are you not assigning any special duty to a hotel compared to Publix?
I'm not, because
So then
Publix would have the same duty. If this was in a public store and there was water leaking from one of its freezer, which is the Sinford case.
Sure.
That I
But it
put
has
in
to
there.
know about the water, which gets back, that's the whole point of the statute. So I don't.
They either have to know about the water or they have to sort of run in circles, but they would have to either know about the water or they knew that the condition was caused by them. We believe it was caused by them because they didn't do any maintenance on this at all.
So, and I thought, so there's no difference, or it makes no difference in the legal relationship between the injured person and the business. So, I mean, the relationship of me when I walk into a Publix is different than the relationship between me and the Marriott that I've paid for a room on. Is that true or not true?
I think the legal relationship may be different because there is that contractual nature to it, but I think the duties of care are the same.
Right. I mean, when I go to a Marriott and I rent a room, I am basically purchasing a product. Am I not? Like I am expecting something that is limited to me. I get a license to use it for a certain period of time, and it's an exclusive license. No one else can come in there during that period of time. Isn't that different than the scenarios that the statute's designed to address? And isn't that just a different theory entirely? If I slip on the floor in a Publix, I don't have a legal relationship with the Publix.
True.
I just walk in there because they've invited me to come and shop and buy some of their products. Maybe I do, maybe I don't.
Yes. And I think.
But they're not providing me anything.
Right, and because of the fact that in this case, Mr. Chambers would have had a contractual relationship, even though I haven't briefed it, I think it would be a heightened situation.
And isn't that the struggle here? I mean, okay, so it seems to me there's a difference factually between someone who slips on a banana peel in a Publix. I'm sorry that I'm dwelling on Publix. I just happen to shop there.
I do too.
And someone who walks into their hotel room that they've paid for, they've been given a key, no one else can access that room at that point, and they walk in and they slip on something because it happened to be consequence of this, whatever was happening with the refrigerator. But it could have been something else too, right? Some other dangerous condition that
Yes.
the hotel owner didn't address.
Yes,
They
I mean,
may
I
have
agree
noted
that
them.
there should be a different relationship. There just isn't any law on it. It doesn't talk about in a situation where you have water in a hotel room. It just isn't anything I could find.
I mean, it happens to be
That's
water in this instance, right?
Right.
But it could have been something else.
Could have been something else.
I don't know, noxious fumes that come from garbage or something they didn't clear the garbage out of the room for a certain time, and the person succumbs to noxious fumes. Isn't that also that's a theory of liability, and suddenly the statute doesn't apply?
It could be, yes.
Thank you, counsel.
Thank you.
I have a question
Oh,
for Council.
Yes.
Council Spano. Council, are you familiar with this court's recent decision in Whitlow versus Tallahassee Memorial Healthcare Incorporated?
I don't know if it's the one that I read late last night. Is in August? Was it August?
Yes,
I might
August.
be thinking of the wrong one. Was it in August?
Yes.
Okay. I am aware of it, but I don't think factually it fit into what we had here.
Why not? Distinguish it.
I'm going to have to look at it again because it was very late, and I kind of put it aside.
Water dripping off the stretcher at
Oh, that's right, yes. I think if the facts, I'm right about it, this court said that the sort of gravamen of that was that the water could be leaking, but that there was no evidence that showed the actual knowledge that the person who was pushing it actually knew that it was leaking, right? I think that this case is different because at least a couple times they knew it was leaking. If their refrigerators were leaking. Now, is there evidence that refrigerators were leaking every single time and that's why they replaced them? No. But they knew that it was a problem.
Thank you, counsel. We'll give you 1 minute for rebuttal, and please add
Thank you.
4 minutes, I think that adds up to for Applebee's counsel. 4 additional minutes.
Good morning, Your Honors. May it please the Court. Samuel Spinner on behalf of the appellee, in this case, Tallahassee Hotel, LLC. The appellee respectfully requests that this Court affirm the trial court's final summary judgment in our favor because the undisputed material facts conclusively demonstrate that the hotel lacked actual or constructive notice of this substance before Mr. Chambers' accident. And I'd like to begin with the statute itself because I think what we've seen from the questioning today is that there are cases where other theories of liability apply, but in a case involving a slip and fall on a transitory foreign substance, the legislature has chosen to eliminate those theories and require that the plaintiff prove actual or constructive knowledge. And that's why we made a big issue of that in our briefs, because Mr. Chambers cited several cases that either predate the statute, and he's made the argument that they can still rely on theories of liability such as negligent inspection, maintenance, or mode of operation. Those theories existed in the prior version of the statute, subsection 768.0710, but they were removed when the legislature enacted the new statute.
It doesn't constructive knowledge doesn't what your brother argues is that these things are leaking all the time and they're having to be replaced every other month, and so basically there is constructive knowledge here.
Your Honor, the evidence does not establish that this condition occurred with regularity. The case law talks about that being an ongoing or frequent problem, and the evidence in this case doesn't show that. As you mentioned in your questioning, this has happened a couple of times. The statute doesn't establish strict liability in the sense that if you have one leak, now every leak in the future is foreseeable and falls under the statute. And
Well,
no
that's not
case-
strict liability. I mean, that's
Not strict
what's
liability.
considered reasonable, and why isn't it up to a jury to decide whether once or twice is enough for notice?
Because no case, at least that we've seen, has found that one or two instances in the entire history of the hotel establishes regularity or frequency in the way that the statute talks about it.
So it's up to us to legislate and add to the statute the specific number of times that is acceptable before there is notice?
No, Your Honor. I believe that the plaintiff had the burden to set forth evidence creating an issue of fact as to whether that did occur with regularity, and our position is that the trial court correctly found that this was not a
What
regular.
would have been enough evidence to establish regularity, at least sufficiently to get to a jury?
If our witnesses.
4 times? 5 times?
I don't know that it's a specific number. It's more of whether.
But not 1 or 2?
No, because it's not whether.
3?
Again, I don't think it's a specific number, Your Honor. I think it's whether the evidence shows that it was a regular, ongoing, and frequent issue that the hotel was constantly addressing, which is not what we have here.
And isn't that what a jury ultimately determines? That is the purpose of a jury, isn't it? To make an assessment based on the community values and understanding of what is reasonable under the circumstances?
Yes, Your Honor, but if that were the case, then we wouldn't have an entire body of case law affirming summary judgment in these cases, because under Your Honor's view, then any issue whatsoever would necessarily have to go to a jury. But we have several cases applying this on summary judgment and even reversing jury's verdicts for entry of directed verdict for the defendant, where the evidence was insufficient to get over the threshold of showing that this was a regular, frequent occurrence. And it's important that we talk about the particular condition, because, as you noted, Mr. Chief Judge, the other instances normally involved a guest unplugging the refrigerator because it was noisy. And that's different because in that circumstance, a guest has unplugged it, and if they slipped and fell on a condition that they created, it would be a little different. This appears to be the first time in the history of the hotel that a refrigerator has leaked water on the floor while it was running. And so under that scenario, this is the first time that this particular condition has happened.
But
Even
can we impute regularity to the fact that room 434's refrigerator has had to be replaced 8 times in the last year, or whatever the number is?
No, Your Honor, because there was no evidence that the replacement was due to the refrigerator having an issue that caused it to leak water. For all we know, the refrigerator door could have been broken those 8 times. And so that goes back to my point that we have to look at the particular condition that's involved in this case. And so the trial court correctly determined that the evidence of frequency or regularity was insufficient to get over the burden of creating a genuine issue of material fact.
Was there any other theory as to where the water came from besides the refrigerator?
There were no other theories presented as to where the water came from, Your Honor. Now, our witnesses did say that they tested the fridge after the accident and found that it was not actively leaking, but they chose to replace it anyway just to avoid a potential issue. But
So
we're not.
a hotel is, well, does a hotel have any unique duty or duty different from Publix? For instance, to a customer to present a safe room? Or is it just the same as what a grocery store would have to present to an invitee?
It is the same in the general sense, but the case law says that the court has to consider the character, size, and inherent risks of the area in question. So we don't look at these cases in a vacuum and say, okay, water leaked out of the one time and someone fell, and therefore there's liability. We have to look at the specific circumstances of how the accident occurred, where it occurred, and we readily agree that this case might be.
Is the element of proof the same in both hypotheticals? Is the element of proof the same in both hypotheticals, whether it's Publix or motel?
Yes, Your Honor, but we still have to look at the way that the accident occurred. And we agree that, for example, if this water had been on the floor of the lobby for several hours, that might be different than the water being on the floor inside of an individual's hotel room for a certain amount of time. And that's why in some cases they found 10 minutes is sufficient when it is in a Publix or somewhere like that. And other cases have found that 50 minutes was not sufficient to impute knowledge when it was inside of an elevator.
So your position is that an invitee in a hotel lobby has more protection than someone who pays for a room?
No, Your Honor, my position is that the case law recognizes that if you have a spill in a public area where any guest or any employee could readily see it and report it, it's different than inside of an individual's hotel room, and we have to look at the specific circumstances of the accident.
So your position is depending on the specific circumstances of each case?
Yes, Your Honor. It's certainly an individualized inquiry, because otherwise the cases, the one case that says 10 minutes was enough would apply across the board, and that's not how it's been applied, because the courts have recognized that we have to look at how the particular accident happened. And in this case, in addition to the lack of the frequency, we also don't have evidence that this was something that we should have continually re-inspected, as you noted, Judge Lewis. And that kind of goes back to the inherent nature of the risk, because we cleaned this room, we inspected it, we released it to be rented to the next available guest as of just shy of 3 p.m. that day, and there's no reason for any hotel to continually re-inspect rooms after they've already been cleaned and inspected, when we have no idea whether a guest is going to check in 5 minutes later or 5 hours later, or not check in again at all that particular day.
Was the water on the floor basically an act of nature or
I know that would call, it wasn't rain, for example, but we don't know exactly what specific malfunction with the fridge, if any, caused this water to leak from it.
Well, yeah, I mean, the reason I asked is, okay, I'm assuming this would be the closing argument to a jury is, the plaintiff, he rents a room at the Holiday Inn, he's expecting a safe room, he opens the door, maybe it was dark, maybe it wasn't, and slips on water on the floor that no one would really expect to be there when they're renting a hotel room. And but your position with those facts, and he's injured, of course, but your position is he has to bear the burden himself for that occurrence. Is that?
Yes, Your Honor.
Is that your
it's
reading
not,
of
it's really not my
Florida
position,
and
Judge.
Florida?
It's really the legislature's position, because they've chosen to modify the plaintiff's burden of proof specifically
for
in
business
cases,
establishments?
in cases involving slips and falls on transitory foreign substances only, and it doesn't modify the burden of proof in other types of premises liability cases, which gets back to kind of my opening point, was that we have to look at these cases different than your example of a Keurig exploding or something of that nature. That's not a transitory foreign substance case, and the theories of liability based on negligent inspection, repair, maintenance, and mode of operation would be available, and those theories have been eliminated in this type of case, and instead the plaintiff has to prove actual or constructive knowledge. And so the mere fact that an accident happens has never been sufficient to give rise to an inference of negligence, and specifically not in a transitory foreign substance case, because they have to prove actual or constructive knowledge, and that simply was not proven in this case.
If the statute didn't exist, does this case go to the jury?
If the statute doesn't exist, then the plaintiff would have been able to proceed on a theory of negligent maintenance, mode of operation, or things of that nature. Now, our position is that we did not have a negligent mode of operation or any negligent inspection or repair procedures. The hotel would have re-inspected the room the next day before releasing it to a guest if it had remained unrented that day. They did what every hotel does, is they inspected the room, they cleaned it, they gave it a 100% score, there were no issues, and sometime thereafter
But then,
it
counsel,
leaked.
the question is, if the statute did not exist, that's the 2010, I think, statute, would the court have denied the motion for summary judgment? Or should the court have denied the motion for summary judgment?
I still don't think there is enough evidence to prove, to create an issue as to our maintenance procedures. But again, it's a completely different scenario, because that statute specifically said you can rely on these theories and don't have to prove knowledge. And the current statute flips that on its head and says you can't rely on those theories and you do have to prove knowledge. And so it's a difficult question to answer as a hypothetical, because it's a completely different landscape of the law with regard to transitory foreign substances. I do also want to touch briefly on the issue of actual notice. In the traditional sense, actual notice would be the hotel caused this leak, they spilled water, or they were aware of it. And in this case, the theory of actual notice is much more attenuated, because Chambers admits that no hotel employee actually spilled the water or saw it. And the evidence is insufficient to show that our installation of the fridge caused it to malfunction and leak water at some point in the future. If you look at the manual, it actually specifically says that the fridge should not be built into a cabinet or countertop. And that's not what this was, as Your Honors recognized in questioning my colleague. This fridge could have been pulled out. It wasn't like, for example, a microwave or a wine fridge that was built into the structure of a kitchen itself and can't be removed. And so our position is that we didn't install it as a built-in, and only the section that says don't install it as a built-in says because it may cause it to malfunction. A separate section says that you should leave certain space on each side, And that section doesn't say that the failure to leave that space would cause it to malfunction.
And that's a factual defense. But do you acknowledge that they do have a viable legal theory under existing common law in Florida about that the hotel has a duty to reasonably maintain a room and all the accoutrements that are found in it?
Yes, Your Honor, we still have a duty to reasonably maintain the room, but to prove constructive knowledge, you either have to have a condition occurring frequently.
But the constructive knowledge is only in connection with the statute, which gets back to my original question, is that, take away the statute for a second. If there's a duty to reasonably maintain a room, isn't there argument to a jury, here are the facts, and it was not reasonably maintained because typically, you don't expect to find water on the floor in a room, and it was, here's our theory, is that they did a bad job installing the refrigerator, and they should have done a better job, and had they done that, then it wouldn't have been water on the floor.
Well, Your Honor, the common law in a premises liability case still requires knowledge of the dangerous condition, but it allows for theories that are not allowed under the current framework and under the current statute, being negligent repair. So sometimes negligent repair or maintenance goes part and parcel with constructive knowledge. So, for example, if you could have never had a prior leak before, so let me take a step back. If the statute doesn't exist, then if you never had a prior leak before at all, the plaintiff could present evidence that, well, if you had had different maintenance procedures and different inspection procedures, then you would have remedied this issue and then the water wouldn't have spilled out at all. That would not comport under the current statute because there would be no evidence of constructive notice based on prior similar incidents or circumstantial evidence showing that the particular condition remained on the floor for so long that the defendant should have discovered and remedied it. Whereas in other cases, if the plaintiff wants to say, well, they negligently maintained these refrigerators and they were constantly leaking water all of the time, the negligent maintenance isn't really the issue. The issue is it was constantly leaking and therefore there's constructive notice. And so,
Counsel, is it your position that in light of Section 768.0755, a plaintiff cannot prove negligence by showing that the defendant acted negligently by failing to exercise reasonable care in the maintenance, inspection, repair, warning, or mode of operation of the business premises?
yes, Your Honor, and that's exactly what the legislature intended when they removed that language from the statute. And as the third, excuse me.
Then how do you reconcile your interpretation of Section 768.0755 with the express provision that the statute does not affect any common law duty of care?
Yes, Your Honor. So the statute doesn't affect the common law duty in that there's still a duty to maintain the premises in a safe condition and to warn of dangers that are not discoverable through the exercise of due care. The legislature modified the plaintiff's burden that would exist under common law and said how you prove that. And one way we can see that in practice, Your Honor, is with regard to the jury instructions, because the premises liability instruction 401.20 talks about the general common law duties, maintain, et cetera. And case law has said that in a transitory foreign substance case that you are entitled to an instruction modifying that, the common law jury instruction, if you will. You're entitled to an instruction modifying that and informing the jury that they can only find liability if they find actual or constructive knowledge. And so it doesn't modify the fact that we owe the same duties that we would owe to an invitee. What it modifies is the plaintiff's burden of proof in proving a violation of what would otherwise be the common law. And as the third district said in the Publix versus Blanco case that we cited.
Before you get there, if I understand your reasoning, isn't it true that under your logic, a plaintiff would no longer have to prove a duty of care, negligent action, or causation because those provisions of Section 768.0710 were also omitted from Section 768.0755?
No, Your Honor. Our position is that we still owe a duty to maintain the premises safely and to warn of hidden dangers. And the legislature changed the burden of proof and what type of evidence is admissible and relevant to proving that when it involves a slip and fall in a transitory foreign substance. because otherwise the legislature wouldn't have removed all of that language and then put a catch-all where all of that language is still in there. That would not make any sense. So we have to assume that by the legislature deleting all of that language from the statute, it didn't intend to just encompass all of it in that catch-all provision. Our position is that the legislature was merely saying, we're not changing the fact that you have these ordinary premises law duties, we're changing the plaintiff's burden of proof and what evidence is relevant. And that's why I think the cases that discuss the fact that you have to modify the jury instructions kind of show that how that works in practice.
What did the customer or this plaintiff, when he opens the door, because of their engineer doesn't know how to maintain the pipes running overhead in the ceiling, he walks in, and as soon as he opens the door, some sewage or something drops down on him and he suffers some sort of injury. Is there,
I don't
does he
think
get to the
that's,
jury on that?
I don't think that's a transitory foreign substance case, Judge.
Well, I know
because-
it's not.
And again,
But the duty's the same, right? So the hotel still has that same duty that we've been talking about to provide a safe room for the customer.
correct.
And I guess, so your position is if the result of some sort of negligent maintenance of the premises, the facilities, the infrastructure, so the pipes, microwave, you could change it and say, well, what if the microwave exploded or something like that? Any of those things, so the secondary effects of that negligent maintenance, they don't have to show active or constructive knowledge in those instances. But if the result of the negligent maintenance of a room happens to be water on the floor, then your client is absolved of responsibility unless there's actual constructive knowledge?
I think that is the way to look at it, Judge.
That's the distinction, and that's what you think the legislature intended, to carve out one particular secondary effect of negligent maintenance of a hotel room?
Not of a hotel room specifically, but they said that if you slip and fall on a transitory foreign substance, you have to prove that the defendant.
In a business establishment.
In a business establishment, you have to prove that the defendant had actual or constructive knowledge. And so it depends on the circumstances in your hypothetical. If this had been an ongoing issue and it had leaked water onto the floor several times and they were aware of it, or if they caused it, meaning that there was clear evidence that the way that they did something with the pipe caused it to leak, then I think it would be different. But the legislature chose to enact a statute that deals specifically with slips and falls. They modified the plaintiff's burden of proof, and if the plaintiff cannot come forth with evidence showing that the defendant created the condition or knew about it, or that the condition existed so long that they should have discovered it through due care, or that this condition happened so frequently that it was a regular ongoing occurrence, then the legislature has said that they cannot meet their burden under the current framework of the statute. Our position is that the trial court correctly found that summary judgment was warranted because there's no evidence of actual knowledge. There's no evidence that we should have continually re-inspected a room that was cleared before the guest arrived. And there's no evidence that this particular condition, being a large amount of water, occurred with frequency, because the other times this happened was due to a fridge being unplugged and a small amount of water leaking, which is completely dissimilar from what we have here. And
Thank
so-
you, counsel.
If I may ask one more question. I'd like to digress back to my previous question to you regarding your logic and interpretation of the statute. What theory of liability remains available to a plaintiff in a slip and fall case such as this under your interpretation of the statute?
Under my interpretation of the statute, they have to prove that we either created this condition or that this particular condition happened frequently in order to meet what the legislature said is the modified burden under the statute. So all we're saying is that you can't rely solely on a negligent inspection maintenance type theory unless that theory resulted in prior similar incidents or the water being on the floor for so long that it should have been discovered. And so sometimes negligent maintenance is part and parcel with constructive knowledge, and sometimes it's not. And in this case, it's not, and therefore the trial court correctly granted summary judgment for the hotel, and this court should affirm its rulings in all respects.
Thank you, counsel. Please add 3 minutes to appellant's counsel's time.
Thank you. I wanted to talk and really, unless there's any questions from the panel, of course, just about the statute and what it does and what it doesn't do. Obviously, in my reply brief, I go through this, but the nutshell version of it is that I call it the new statute, the 2010 statute, does not do away with all the things that were specifically set forth, the ways that you prove negligence, either inspection or maintenance, even mode of operation. It says specifically, it does talk about notice, but it says specifically that these common law duties are still there. And what it also does is and as I think has been alluded to by my opponent here, it weaves that within at least the constructive knowledge, because it talks about a duty of care. It talks about care. So this concept that now that we have this extra prong of actual constructive notice for transitory substance cases, that means that you don't have to prove anything else. That is not bear out for by anything. I don't think there's any case that they've cited to that says that. And so the ways that you prove negligence, in this case we have negligent inspection, negligent maintenance, maybe even mode of operation. All those ways that we prove negligence that we did prior to 2010, we can still do after. And we know this because at least one court, it's the Oliver Court in the 4th District, said that these cases are still negligence cases with the added element of proving actual or constructive notice or knowledge. So I think this concept of that you can't prove it anymore by that is just not borne out by the statute, by the case law, by anything. And so what we have here is we have a negligent inspection and maintenance case. And just the last thing I want to say to the court, unless there's any questions, is that this case was on a summary judgment. This wasn't a jury trial. The jury didn't look at all the evidence to say, well, we don't think that there was a breach of care with their inspection or maintenance, and there was a no verdict. This is a summary judgment, and issues regarding foreseeability of a condition, whether they should have foreseen that their negligent maintenance would have caused this, those are jury questions, period. And the trial court...
What about your opponent's position that, even just taking the evidence in the best light of your client is once or twice, and that doesn't count as enough, as a matter of law, doesn't count as enough?
I disagree, because regularity isn't defined under the statute. It isn't defined in any of the cases. And so regularity, when you show regularity, you have to show something before. We have shown at least one or two. Now, is that enough? I don't know that. But a jury has to determine that. There's nothing that they have given you that says that a trial court, if there is evidence, albeit one or two times, that this has happened before, that that's not enough. That it has to be a certain amount. Or that the trial court can make that decision itself, meaning that they could weigh the evidence and say, you know what, that's not enough. There is no case like that, because there should not be any case like that. The jury has to make that determination. And when the trial court made the determinations it did in this case, it took that away. We're just asking the court to reverse so that the jury can make those determinations. There's nothing else?
Thank you.
I thank the court.
All right, we're adjourned.
All rise.